All right, Rick. Well, we are here back for another day, a day different than days in the past. But really, what we're talking about here is the Duncan v. Bonta case, previously known as the Duncan v. Becerra case. Now, we just got a ruling, or an opinion, rather. An opinion that was not favorable to us.
Correct.
And I thought that we could maybe just go through this a little bit because there's a lot of different aspects that we can look at it through. But I guess we can just start with the opinion. What was it, 7-4?
7-4. And I think before we go too far on the opinion, one of the things we need to realize is, as in all things, a lot of our allies, a lot of the members of our community cannot wait to pontificate on all things Second Amendment. That's part of the beauty of our community and part of the fun. But sometimes we carry that habit into something like this ruling, and we start saying things like, California Rifle Pistol Association lost their case. We're losing this, we're losing that. And this is a total shock, and a lot of hyperbole. So I just want to start off with, from the day we filed this case, the general assumption was this day was coming. We would be here.
By here, you mean going to the Supreme Court?
Yeah, by going to the Supreme Court. I mean, it's basically, look, pretty much every Second Amendment case starts off with the lower court. And either you get a favorable decision if you don't. And if you get a favorable one, you go, yay, we won. The state was wrong. But then this is the state of California. And the state of California has an agenda. And that agenda in general is not favorable to the Second Amendment community, which is why whenever the extreme left says, we're all pro-2A, and a good chunk of our population is like, well, maybe they are. I'm like, are you kidding me? If you look, this is a routine. It's not hyperbole. It's not somebody faking evidence. It's just out there. You can read it over and over again. The state, when it does not win, automatically appeals to the Ninth Circuit. And when it goes to the Ninth Circuit, there are basically, a couple of options. Option one is a 3-court judge panel, which is the general panel of the Ninth Circuit, votes in your favor.
Which is what happened with Duncan v. Becerra.
Correct.
Where you could have said we had a victory because we had an opinion that was favorable to us.
Right. So, and I'll go back through Duncan v. Becerra, how it's trained up. But then if the state, going along with that line, if the state doesn't like the decision of the 3-judge panel, then the Attorney General, in this case, Bonta, can go, maybe those judges weren't thinking properly that day. Let's have 11 judges look at what they did. And that's called an en banc. And then if the en banc upholds, then that's the law of the land for the Ninth Circuit, which just is in California and several other states that comprise the Ninth Circuit. Or it gets kicked up by either side to the Supreme Court to say, well, what do you think at a national level? Now, to go back to Duncan v. Becerra, the court path was, we took it to the lower court. Now is where the Honorable Judge Benitez, called St. Benitez by some in our community, did several things that I think are worthy of review. One, he said the state was absolutely wrong. It didn't apply something that you're going to talk in a couple of minutes about, called strict scrutiny to the case. He gave several examples of why this was a violation of our rights, and didn't exclude that just to the Second Amendment. And then put a wonderful motion with a built-in stay to that motion at the end of it, which allowed for what was commonly known as Freedom Week, where all the firearms magazines that you had that were standard capacity, mean greater than 10 rounds, you're allowed to keep because they were grandfathered in by that ruling. And then anything you purchased during that 7-day period called Freedom Week, you got to keep. That was yours. And that has had several things that have come positive that we'll talk about later. And then that case got appealed because the governor didn't like it, so he directed the Attorney General to move it up. And so then it went to the en banc, which is where we're at now. And the en banc panel, after the 3-judge panel had said, no, Benitez was right, on a 2-1 decision, it came to this decision where we had 7 democratically appointed justices versus 4 Republicans. Interesting enough, surprise, surprise, 7-4 opinion. And as you've discussed pre to this with me, quite a colorful commentary in the, I believe, 319-page document, something like that. It's like a book to go read. And that brings us to where we're at now.
So let me just get this straight. First of all, I have heard a little bit or a few people kind of ask me, is this the same case? The answer is yes. The person on the other side of Duncan, who is now Bonta, is a representative of California. That's
Right.
the Attorney General of California, who previously was Xavier Becerra, despite how some people pronounce his name.
You mean like President Biden?
Yeah, when he said Javier Baccaria or whatever it was, that was pretty funny. So if you're looking at that name change thinking it's possibly a different case, no, it's the same case. And so the pathway to this, there's been 3 opinions on it. The 2 opinions, the 3-judge panel at the Ninth Circuit, as well as the federal court, which was Judge Benitez, gave us a favorable opinion to our cause here at CRPA. It's the en banc panel that didn't. And that's actually where I wanted to discuss scrutiny. To be 100% honest with you, I mean, you hear, generally what the opinion is, but when I started reading it, it's literally the second page. Yep. Where you throw your hands up and you say, well, here's how they reached this opinion. The one difference between the 2 opinions that went in our favor and this opinion is the level of scrutiny that they held this case to. And for those of you who don't know, I mean, I'm not a lawyer, but the best way that I can try and describe this is what scrutiny is generally is the lens that they view this argument through. Are you going to hold it to an intermediate standard, or are you going to hold it to a strict standard? And what those standards are actually very carefully defined. And Jacob, if you can pull this up here, because I've pulled this up. What website is this from? If you scroll up to the top here.
It's findlaw.com.
Okay, findlaw.com. They define scrutiny, and what caught my eye most here when they defined strict scrutiny is that this high level of scrutiny is also applied whenever a fundamental right is being threatened by a law. I think that's a very important point that Judge Benitez was making, as well as the 3-judge panel. So,
can we hang out there for a minute?
Sure, let's hang out there for a minute.
I mean, I think one of the things people have to realize is sometimes people conflate that strict scrutiny is like being legalistic. No, it's not. It's what all of us have dealt with, whether we're children or parents or grandparents, that when you tell your kid very strictly, if you touch this, you will get burned. It's really not a debatable point.
Right.
It's just, it's set there so because you don't want the person to get burned, so don't touch that. It's not to try to diminish it. And this is what strict scrutiny says. It's that funnel that says, here is the narrow thing of what the framers or the people that wrote the law wanted the law to do. And so this is how you look at it, which is what I believe Justice Scalia tried to hand us back with Heller, was like, this is what this means in the Second Amendment. And then as you go to, as it says up here, intermediate scrutiny or rational basis, that funnel gets wider and wider and wider and allows for greater interpretation. So you could say, well, it means this on Monday at 2:00, but Wednesday by 4:30, it's 180 degrees in the opposite direction.
Well, and this is kind of where it ends up chapping me. So first of all, I think it's important to understand, because you hear a lot of arguments out there saying that judges are really supposed to reside outside of politics. However, judges are people, and people are involved in culture. So when it comes to a lens that you look through, doing intermediate scrutiny as opposed to strict scrutiny is basically a lens saying that this magazine case is not defined as part of a firearm, which is defined as part of our Second Amendment rights, as a fundamental right. I think culturally, the way that we think about these things, that is where the biggest disagreement ends up happening. And, it's like you want to pull it into intermediate scrutiny and you want to give it a little bit more wiggle room for interpretation. How many of the amendments to the Constitution or the Bill of Rights, how many of those things actually get opened to more interpretation? How much wiggle room do these other rights that we call inalienable actually have compared to the Second Amendment? I feel like the Second Amendment and firearms in general are looked at differently than a lot of other rights that were, defined for us.
Well, I think there's 2 points you bring up. The first one I would highlight is when you were talking about judges, before you get to the level of a judge of a Ninth Circuit and stuff, I would say the vast majority of those judges got to positions, quote, the farm team for it, through our votes, Kevin.
Yeah.
And, if you're seeing some of these judges and you're like, well, how the heck did they get there? Because people like us didn't pay attention and voted for them. And so I think a lot of the judges coming up the ranks look at this and say, like, how do I test the weather in my area so I can eventually get there? Because it's a career path for them. So to say judges aren't political, I think, is a falsehood. The second part of this is I believe that we've got to start looking at rights under the Constitution as understanding that, if you're fighting for women's rights or you're fighting for your business's rights or commercial rights or whatever those rights may be, there is a segment of our society that wants to water them down and take them away from you. And there's a segment that believes in it. And I believe that, like, hey, if they're going after, another right named under the Constitution, under one of our amendments, that I need to fight just as hard for the people there, whether it directly impacts me or not, as they should be fighting for this one. And I say it all the time. You lose the Second Amendment, you will lose the First. And people guffaw on that on both sides of the political spectrum. But I'll challenge you, how much First Amendment rights does the people of Australia have now that they've lost any semblance of what used to be kind of their own Second Amendment?
Well, no, absolutely. You have to tear down the gate before you can burn the town, right?
Right.
And this is kind of the issue. They have stigmatized our Second Amendment as something that's held to a different standard than all the rights because they realize the Second Amendment is the gate. And when you read it in the opinion. Okay, the rationale here for these or at least for the author's opinion, who I believe was a judge out of Oregon, was that this law puts minimal burden on the owner or on the citizen. But let's think about that in more of a general basis. And the one that comes to my mind is unlawful searches and seizures. If there was an unlawful search or seizure of me only because it puts minimal burden, is that really a standard that we want to hold ourselves to?
Well, and I would also say, what about the unlawful burden? You're a new dad, so you've joined the ranks of people like me that are dad, and we got moms out there, and this would apply to them equally. Look, the issue in being a parent is inherently you want to protect your children, and for those of you who aren't parents, you want to protect your significant other. Yourself. Mm-hmm. Reality. Whether you love law enforcement or have a negative opinion towards law enforcement, fact is law enforcement can't be everywhere. They are in 99.9% of the cases responding after the fact. Mm-hmm. Which means when you tell me in my home, which is what this decision would be saying, I get 10 rounds in a firearm to defend myself, when law enforcement repeatedly says, I am facing 3 to 4 people who are criminals, who are not carrying 10-round magazines coming at me. How have you made this fair? How is this burden in any way, shape, or form not slanted against me? Like I have an incredible burden to try to take care of my family, and you've handcuffed me and gave the enemy the advantage.
And that's a more practical example. That's not even necessarily an example that resides under strict scrutiny and our rights. That is just like, look at the statistics. Mm-hmm. Look at the statistics for when people are in high stress situations and how they use firearms to either save their lives or not. And you're really not leaving the firearm owner a very good shot, which is the argument in the lawsuit. Right, mm-hmm. That is the argument that we brought forth, and we've kind of gone down this rabbit hole. But basically, the point that I was trying to make is, You can identify where these judges were coming from on the second page of this opinion.
Correct.
When they said they were going to be looking through the lens of intermediate scrutiny. And that was the difference, and that ultimately is why we are able to get an opinion that does not favor our viewpoint here, because they're not looking at this as a fundamental right. And honestly, again, because this is our opinion, right? I think that's wrong. I think they got it wrong. Fortunately for us, though, similarly to not necessarily the Judge Benitez opinion, because we got Freedom Week after that, but after the 3-judge panel looked at this and gave us a favorable opinion, today nothing actually changes.
Correct.
Right? So we have the stay on the law, so they are not able to enforce this law. Yes, we got a bad opinion, but we're appealing it to the Supreme Court.
Which is where we assumed it would go from the very onset.
So all in all, good opinions, bad opinions. We did get Freedom Week out of this lawsuit, which is something we didn't necessarily know we were going to get.
Right.
But it is ending up in the place where we thought. Can you sort of enlighten me from here? There are, I'm sure, several different things that can happen from here. What are the outcomes looking like that are possible here?
So here's the thing. I mean, we've got a lot of people that are kibitzing and pontificating on multiple options. And the first thing I want you to know, nobody knows exactly, or even probably greater than 50-50 chance of what's going to happen. But I would say these would probably be the most predominant at this point options. And if you can go to the next area, Jacob, and you'll be able to see this down below. This is from Cornell Law. This basically is kind of like a really quick primer so you can see how this works. So CRPA, at this point with the decision, our lawyers have filed what is known as, in legalistic slang, a cert, which goes up to the high court and says, hey, we would like to have the Supreme Court look at this case. Now, the Supreme Court has a process for doing that. And that process is the court has to look down and say, yeah, we think this is a fundamental right. Yes, we think that the justices in the previous court that this was is being appealed from got it wrong. And to do that, it takes 4 of the 9 justices to say, yeah, we want to hear this. Now, that process has incurred that, cases across the board, not just Second Amendment cases, filter up. Everybody looks at them. The Supreme Court clerks gather them up. They gather little different groups made up of different justices, depending on what the subject matter is. They look at and they give it the thumbs up, thumbs down. The first point I want to make is just because the Supreme Court says, no, we don't want to listen to this case, doesn't mean they agreed with the lower court. That is a falsehood. It could just be that's not their favorite case to make a ruling on. And so many times in different districts, there's more than one case. So for example, as this one goes up, there's another magazine case that I don't remember off the top of my head that is up there that they'll be looking at. That's actually to our benefit. So before anybody goes running around going, oh, well, see, this is what, no, that's to our benefit, because when you have different opinions in different districts, that actually elevates and is a positive thing for the Supreme Court to say, well, we've got different parts of the country can't agree. We need to step in.
Yeah, so it's like it raises it on their list of priorities, maybe even take it sooner than they would have had it not.
And so that is one of the reasons I'm very favorable in the mindset that they're going to take it. Next on the list is the Supreme Court could, and a lot of people haven't talked about this, but one of their options is currently we have the New York case that we won't know till June, how they decide it. There are 2 largely well-defined camps of pundits on this one. One camp is this is going to be a decision that's going to come down in our favor, which, by the way, camp number 2 says the same thing. So I think it's safe to say that the vast majority of pundits think we're going to get a favorable ruling. It's the outcome of those rulings. One is a very expansive, reaffirming the Heller case and what Scalia asked for, which was strict scrutiny be applied, is the law of the land when interpreting the Second Amendment. The other one is no, they're not even going to discuss scrutiny. They're only going to discuss these fine points of the case, and I have friends in both camps that have talked about this. What is interesting is several justices on the Supreme Court specifically asked scrutiny-based questions of both parties in the New York case. So that further suggests if they weren't even considering that option, those questions wouldn't come out because they're not frivolous that way in the Supreme Court. So based on, let's just say that what our own Chuck Michel thinks is going to happen, we get that scrutiny test. The Supreme Court could say, we're going to kick Duncan back down to the Ninth Circuit and say now that scrutiny is the law of the land, strict scrutiny in particular, re-examine your facts, which would suggest a win because given that the lower 3-judge panel had abided by strict scrutiny, that could automatically flip this case in our favor.
Right.
The third and last option is they hear it, they listen to it, and then at that point, if 5 justices affirm it and say the en banc was wrong, that's law of the land. And if for some reason we didn't get 5 justices to affirm it, then there would be a period of time that Californians would have, I think roughly, don't quote me on it, but it'd probably be 2 weeks, maybe a few days more. And then there would be this is what you have to do to be compliant with the law. So that's what lays out there. So the fact that the vast majority of the options in play right now are still favorable to law-abiding gun owners, it's been a little disheartening for me to see some of the people jump out of the blocks with this is the end of the world when we know it, when right. Nothing's changed in the last couple of days, and we're still looking pretty good.
Yeah, okay. Well, I mean, that was actually enlightening for me, so thank you for that. I think we've already answered a couple of the big questions that we end up getting when something like this happens. What's the outcome? And I guess I can reaffirm that. The outcome is we are exactly where we anticipated being. Mm-hmm. We're going to the Supreme Court. Regardless, we could have had 3 unfavorable opinions, and we would still be in the exact same spot. We could have had 3 favorable opinions, same thing. Another question, though, what's the time frame? So let's just look historically and think about this for a second. Duncan v. Becerra was filed in, 2016?
Shortly after that, yeah.
Shortly after 2016. We then got a decision from Judge Benitez in 2019.
Correct.
A decision from the 3-judge court in 2020. And now the 3-judge en banc in 2021.
11-judge en banc.
I'm sorry, 11-judge in 2021. So these are not days or weeks apart. These things are years apart.
And this one, most likely, with us filing it as we are, this has a good chance of being heard in October-ish of 22, with the decision coming down, if they hear it, they choose to hear it, then that decision would come down sometime probably middle of the year of 23. If they chose to send it back to the lower court because of the ruling, we'll get this June of 22. So really, we're not going to have a bird's eye view of what's going on until we get into the gap of June of 22 through October. They either kicked it back down, said, use this scrutiny thing, or it floats back up and then they tell us whether they're going to hear it or not in October. And then if they do hear it in October, then we wouldn't know anything until the following June.
Yeah, and I think it's important to just kind of have that outlook and expectation. I mean, ultimately, when I end up having these conversations with people, it always ends up getting drawn back to, like, we need to get these legislators out of office, right?
Yeah.
Because it's a law that was, formed in 2016, and here we are, outlook 2022, 2023, finally striking it from the book. But it is good to at least set the expectation for yourself. We're in this for the long haul. We feel good about it, but it's not something that happens overnight.
I'd like to make 2 final points. One is, when we talk about where this started, it started with a proposition that was put forward by the governor that we currently have, Newsom. And that proposition was labeled safety for all. And it's been reprehensible to me, the number of members of our community that said, oh yeah, I voted yes on that proposition because it was safety for all. Folks, you got to start reading stuff, not just going in a booth or looking at something in the mail and just checking off yes or no. you need to actually look, because the tagline, safety for all, was actually not about safety in many respects.
Well, yeah, and this is the this is the conversation that we have about high information voters. These are the people who go out and make sure that their morals and their opinions are being represented by the people that they're actually voting. And it's very unfortunate that the game is played this way, but the politicians that write these bills know that most people aren't going to actively seek this information out.
Right.
So they do label it with something like safety for all. And yeah, I mean, how easy is it to look at a tagline and say safety for all? Yes, sir. So we're going to continue and be diligent and try and get this information out. Any individual information that can be done, though, should be done when it comes to these sorts of things.
Point two, taking along that, we are going to be publishing information, updates on this throughout this entire process. So if you're not subscribed to this channel or to our website, please do so you can keep abreast of the facts, since we're the ones actually trying this case. You can get it straight from us without any hyperbole or the telephone game changing what's actually going on that happens in our community. But finally is the other question, so what is this process? And I think this is where the American people, and I say the American people, not Californians in this case is no longer a California-only case. This case is now at the national spotlight, and people are like, okay, but Rick, if the Supreme Court did the worst option for us and voted no, it just impacts California. Yes and no. Yes, legally, we're going to be the first ones to suffer. But for those of you that are watching this, or this is being shared with out of state, you got to realize something. This is just one of many examples of, if they get away with this in California, it is coming to at least 20 other blue states within months, not within years, within months. And given the fact that people will have seen in that event of a loss, there's not even going to be lawsuits. And so this kind of a case takes a lot of money, just the costs for all the documents, because they have to collect every single court document from the start of this back in 2016 forward and make copies for all these different members of the Supreme Court, everybody. The copying costs are astronomical, let alone the human hours taken to prep for a Supreme Court case. This is a well over $1.5 million from this point forward. And that doesn't happen without a lot of assistance. And so please, folks, if you're not in California and you're like, I would like to keep my standard capacity magazines, please go to our website at www.crpa.org, or you can call in at 714-992-2772 and give to the litigation fund on Duncan, because we've got to raise this money to keep this going.
There's lots of positives and negatives in the California legislature, but what's always positive? A like on this video. So be sure and like, share, and subscribe. Make sure and hit that little bell so that you can stay tuned for all of our future videos. You can also check us out on Facebook and at CRPA.org. If you're looking for up-to-date legislature notes and things that are going on in the courts, the website and these videos are a great place to find it. So be sure and follow us, and we'll see you next time.